So basically we can continue with our debates. I hope you enjoyed the cakes, which I personally think are really lovely, and I can't wait to have another one after the panel. We already suggested what would be the topic of this panel, because it somehow naturally follows from the previous debate. And that would be the raison d'être, we can say, or the way international arbitrage system works. So if we want the state-investor dispute mechanisms, and why they are here, why do we need them, what are their vested interests, if there are any, and several other questions which I will raise before the presentation of our key speaker, who is Jonathan Bonnitche from London School of Economics. He works there as a researcher. He is now finishing his book on cost effectiveness of costs and benefits of government for the government in bilateral investment trade treaties, and he also served as an advisor for Australian government, if that is correct. And on my right is Mr. Václav Rombald from Credit Insurance Corporation, which acronym is EGAP, Exportní a garanční pojišťovací společnost. And he is basically a foreign or external relations lawyer. So I'm very happy that he could make it today. So that again we can have a more general debate and then anchored to more specific Czech or Central Eastern European context. And before Jonathan outlines his ideas, let me again propose three broader questions which would be good if we could keep in mind and filter all we hear through these three questions, and then possibly try to find answers to these questions. So first would be, how transparent, accountable and neutral are international arbitrage panels or international arbitrage system? However, actually not so straightforward may be the definition of what we mean by transparency, accountability and neutrality. So we'll have to go to the very conceptual level to get the answers. Second question could be, do international arbitrators take into account public policy concerns? Should they actually take them into account at all? If yes, do they do it when evaluating the cases? And third question may be basically, what is the main area of specialization of Jonathan, that is cost effectiveness, cost and benefits accruing for the governments from bilateral investment trade treaties. Jonathan, the floor is yours.
Thank you, Ivan. I take the microphone.
Please do.
I'm very grateful to the organizers for inviting me here to speak. I really enjoyed the first panel and I learnt a lot. I think this sort of format, actually, for me, coming from academia, is very useful, getting representatives of government and civil society and academia and practitioners in a room together to share their views and their different perspectives. As Ivan mentioned, I'm currently working part-time for the Australian government. The Australian government's having, at the moment, its first experience of defending a claim under a bilateral investment treaty. So I think we've got a lot to learn from the Czech government, which as we know, has a lot of experience in defending these claims and often in defending them very successfully. But I should say, and especially because the subject of my speech is about transparency, in the interest of transparency, I should say that I'm here today speaking in my personal capacity as an academic. That's my main job, my main line of work is as an academic at the London School of Economics, and I'm not here in my capacity on behalf of the Australian government, so I'm not speaking for them in any way. So just to begin by framing the discussion, I think this is useful because of the way that the issues came up on the previous panel. I think it's useful to distinguish between the substantive questions relating to investment treaties and the procedural questions. So by the substantive questions, I mean, how much protection do these treaties provide to investors? Are investors only entitled to compensation in the case of direct expropriation, in cases where, for example, the army comes in and seizes a factory? Or do investment treaties also provide investors broader protections when governments introduce regulatory changes that affect the profitability of an investment? So these are the substantive questions. These are about how much protection do investment treaties provide to foreign investors, and these questions have been very controversial. People have argued that investment treaties provide too much protection to foreign investors. In contrast to these substantive questions, there are also procedural questions. And the procedural questions mainly concern the way that disputes under investment treaties are resolved. And as we know, almost all investment treaties set up these arrangements of compulsory investor-to-state arbitration. And this is the procedure by which a tribunal will be given the power to adjudicate on a claim under a treaty, to interpret and apply the treaty, and to decide a case. There, of course, may be some sort of connection between the procedural and the substantive issues. For example, if tribunals tend to interpret things in certain sorts of ways. But I think, at least as a starting point, this distinction is quite helpful to direct our discussion. And the three questions I've been asked to address today are mainly focused on the procedural issues. So questions about investor-state dispute settlement as a way of resolving investment disputes under investment treaties. And the first question I've been asked to address is how transparent, accountable, and neutral are international arbitral panels when they decide investment treaty disputes? So, to begin, this may be familiar to many people. There are basically two sets of rules that are used to decide investment treaty claims. So there are two different sets of procedural rules that govern investment treaty arbitration, and which set of rules will be used depends on the treaty in question. So the treaty in question will normally specify one or the other set of rules, and one set of rules is the ICSID rules. That's the International Convention for the Settlement of Investment Disputes. ICSID, it's a arm of the World Bank. So that's one set of procedural rules for investment treaty arbitration, and the other set of rules is the UNCITRAL rules, which is the United Nations Convention on International Trade Law. So, bearing that in mind, the question of how transparent, accountable, and neutral are international arbitral panels, the answer to that question depends somewhat on whether we're talking about the ICSID rules or the UNCITRAL rules, because there are minor differences between them. So, to the question of transparency, the ICSID rules provide for more transparency than the UNCITRAL rules. But there are attempts at the moment to renegotiate the UNCITRAL rules to provide a higher degree of transparency. That said, even the ICSID rules as they are now don't provide the sort of transparency we would expect in a domestic court system. So, under the ICSID rules, when an investor files a case against a government under an investment treaty, so we have an investor-state dispute, it's going to arbitration. Under the ICSID rules, the fact that there is a dispute has to be made public. So the Secretariat is obliged to publicly list that there is a claim, but they're not obliged to provide information about the nature or content of the claim, and the ability of people like me and others in this room who are interested in particular disputes to find information about what's going on just really depends on whether either the investor or the government that is being sued is willing to disclose that information. There's no obligation on the disputing parties to publish information relating to what's actually the substance of the dispute. The proceedings themselves are not open to the public. The pleadings of the two parties are not released to the public, and the final decision is normally released to the public under the ICSID rules. But if the parties both refuse to release the decision, then the ICSID Secretariat will provide a summary of the decision for public release rather than the whole decision itself. That decision, of course, only comes at the very end of proceedings. So at that point, maybe the proceedings have taken 5 years, and it's only at the end that we really discover the full detail of the issues, the substance of the dispute. The UNCITRAL rules, as I'm saying, I won't say much about them because they're currently up for revision, and it's not clear what form those revisions will take. But as they're currently drafted, they provide even less transparency than the ICSID rules. So how does how transparent are international arbitral panels?
Can I just,
yeah.
Is it clear to everybody's UNCITRAL and exit rules, or do you feel like we need to exit? And because I'm personally... What?
Yeah, the International Convention for the Settlement of Investment Disputes, so that's ICSID in English, ICSID. And that's one set of rules. And the other ones is UNCITRAL, UNCITRAL, which is the United Nations Commission on International Trade Law. And those are the two different sets of rules. And which set of rules would apply depends on the investment treaty in question, which will normally specify one or the other rule sets. How accountable are arbitral panels? Well, arbitration is traditionally understood as a way of resolving disputes where the tribunal is accountable only to the disputing parties. So the traditional idea of arbitration is that people agree to resolve a dispute in a certain way. It's a private form of dispute settlement. The tribunal that is constituted under this agreement to arbitrate the dispute is accountable to the parties, but it's not really accountable to the public at large. And that's reflected in several parts of the rules, particularly the rules governing how an investor or a state might try to get an arbitral award overturned or to appeal. So there's basically no appellate mechanism. There's no possibility of appeal against an investment treaty arbitral award, and there's only a very limited possibility for what's called annulment, which is a form of review. It differs slightly under the two sets of rules, but there's a very high threshold that a party must prove to try to get an award annulled. So investment treaty arbitration has relatively limited mechanisms of accountability to other forms of legal review. Also, relatively limited accountability to amicus curiae. There have been some changes to the rules allowing for third-party submissions in arbitration for amicus curiae intervention, but generally that's been put into the discretion of the tribunal itself. So it's up to the tribunal to decide whether it will allow amicus curiae to intervene in a case, and if so, whether to pay attention to what they have to say. So that's another relatively limited form of accountability. And then another way we might think about accountability is accountability to the states that signed the treaty in the first place. Occasionally, and I'm thinking particularly here of NAFTA, the North America Free Trade Agreement, which contains an investment chapter, occasionally investment treaties do set up a system of accountability to the states that are party to the treaty. And so under the NAFTA system, that's a procedure by which the parties, that this is the governments in question, Canada, the US and Mexico, can come to an agreement about what they think the treaty means. So they can give an authoritative interpretation of what they think a provision of the treaty means, which is an accountability mechanism of sorts. It's accountability to the state parties. But most investment treaties don't have that sort of accountability. So it is completely within the discretion of the tribunal how it would interpret the provisions of a treaty that arise in a dispute. So again, relatively limited forms of accountability of investment treaty arbitration. What about the neutrality of investment treaty arbitration? This is a difficult question, and it's one that's been contentious. In the first instance, it's important to explain how a tribunal is constituted. So a tribunal comes into existence when there is a dispute, and then the investor will appoint one arbitrator, the state will appoint another arbitrator, and then the investor and the state will try to agree on the third arbitrator who will preside over the panel. And then those three arbitrators together will hear the case and decide the case. So is that way of resolving disputes neutral? Was clearly not neutral if by neutral we mean independence from the parties, because all the arbitrators are appointed by the parties to the dispute. So they're not independent from the parties. However, the panel in principle is neutral if by neutral we mean balanced as between the investor and the state who appear on either side of the dispute, because both the investor and the state appoint one arbitrator, both the investor and the state appoint one arbitrator, and then they, together, the investor and the state, agree on the third arbitrator. So neither side of the dispute has the advantage, in principle, of stacking the panel with its own appointees. Where this gets more interesting and more difficult is discussions about the sorts of ideas and predispositions that arbitrators tend to bring to these disputes, and I think the idea of epistemic community is really helpful here. I'm not sure how well that translates into Czech, but this is
epistemologická komunita. I think that's
thank you.
For the Czechs.
So it's this idea that a particular professional community, in particular small professional communities, often share quite a coherent understanding of what their role is and how it fits within a certain institution. And I think it's fair to say that most arbitrators tend to share a common understanding of what their role is and what the role of the investment treaty system is as a whole. So I'm going to move on very quickly to the second and third questions. I can see that my time is ticking. The second question was, do arbitration panels take into account public policy concerns when evaluating cases? So to begin, it's important to note that most investment treaties actually say very little about public policy concerns. So the treaties themselves don't tell the arbitrators whether or not they're supposed to take these concerns into account. There are some minor exceptions to that, and this recent Canadian practice was mentioned on the previous panel, where Canada has recently started to include treaty language saying that certain sorts of public policy issues don't constitute indirect expropriation. But for the most part, investment treaties don't tell an arbitrator whether or not they should consider public policy concerns, and if so, how they should consider them. So the fact that there's very little guidance in the treaties goes some way to explaining why different arbitral tribunals have come to such different views about whether they should take these concerns into account, and if so, how. And I won't at this point launch into a big run through all the cases, but just to give two very brief examples, in a recent controversial case, it was the case of Suez in Argentina. It involved a privatized water concession contract in Buenos Aires, and Argentina basically argued that its decision to restrict the ability of the investor to raise the water tariffs. So Argentina had prevented the foreign investor from raising the price of water. And Argentina argued that this decision was justified by the human right to water. So although it had interfered with the investor's operation of its business, that interference was justified by the human right to water. And the tribunal basically said, well, we're not concerned with human rights. This is an investment tribunal, not a human rights tribunal. It's up to Argentina to comply both with its investment obligations and with its human rights obligations. And here we say that this restriction on the price that the investor could charge was a breach of the investment treaty. So that's one approach where the tribunal didn't pay much attention to public policy concerns, and a very different approach in a case, Duke Energy in Ecuador, where the tribunal said that when it applies the investment treaty, it must take into account all circumstances, including not only the facts surrounding the investment, but also the political, socioeconomic, cultural, and historical conditions prevailing in the host state. So there we have a very different view where the tribunal thought it was very important to consider public policy concerns as one element in the balance when it was implying the treaty. So in answer to the second question, which was, do arbitration panels take into account public policy concerns? The answer is some of them do and some of them don't. Focus question 3 was, how cost effective are investor state dispute settlement mechanisms for governments? And here I'm focusing just specifically on the process of settling disputes by investment treaty arbitration. So I'm not trying to provide an overall evaluation of the costs and benefits of investment treaties as a whole. I'm just looking particularly at this procedural question as a way of resolving disputes. How cost effective is investor state arbitration? Well, the proceedings themselves are expensive. There's a lot of variation. It depends on the complexity of the case. It also depends to some extent on how the case is run in procedural terms. But generally, the cost for each party of their legal representation is normally somewhere between 5 and 10 million US dollars. So each party will have a legal cost for proceedings, on average, roughly of 5 to 10 million US dollars. In general, if you win the case, you don't recover your costs from the opposing side. So if you're a state and you successfully defend a claim that's been brought by a foreign investor, you'll still be left with at least some of your legal costs. You won't be reimbursed for the costs you had to pay to defend the claim. The same is also true for investors. So if investors are successful and the tribunal decides that actually the state did breach the investment treaty, in general, the investors won't be able to recover their full legal cost from the host state. So much of the cost will just be left. So that's the cost of the proceedings themselves. What about the cost of the actual arbitral awards? So if a foreign investor successfully sues a government, how much are they likely to win? It's almost impossible to generalize about this. It clearly depends on the circumstances of the investment, the size of the investment, and how significant the government's interference with that investment was. So to give you a range, in Bywater and Tanzania, the investor won the case, but they received no damages because the tribunal said basically, while the government has expropriated the investment, and so they agreed that the government had expropriated the investment, the investment wasn't actually worth anything anymore, because the investment in question was a contract, and the investor had so significantly underbid on the contract that the ability to continue to perform the contract wasn't worth anything. So the investor won, but they got nothing. That's at one extreme. At the other extreme, we have Occidental and Ecuador, a recent case where the investor won $1.7 billion US. So we have potentially broad range of claims and a broad range of awards, even when investors are successful. I don't think averages are very helpful given the enormous spread here, but if we were to look at averages, other people have said that the average amount when the investor is successful awarded against a host state is about $40 million US. But whether we should think of this as a really large amount or a relatively small amount, again, depends on the size of the investment and the scale of the issues in dispute. So in a recent dispute between Chevron, the oil company in Ecuador, Chevron won $96 million US. That sounds like a lot of money, but in the context of how much they were claiming and the scale of the amounts in dispute, that would have been an amount the Ecuadorian government would have seen as a very small amount, and the Ecuadorian government probably would have been very happy with the outcome of that claim they had. I won't go into the reasons for that. On the other hand, in a case which many of you will be familiar with, which was the CME and the Czech Republic case, I believe the amount that was awarded in damage was $270 million US, and for the scale of the investments in the media industry at stake in that case, that was an enormous amount of money. So difficult, again, to generalize about the costs of investment treaty arbitration. So I'll leave it there, and hopefully we can come back and pick up some of these issues in discussion.
Excellent. Thanks a lot. Thanks a lot, Jonathan, for very succinct and clear analysis and answers to 3 questions. Maybe before I leave the room for Mr. Rombald's comments and his own ideas, I would just like to position the debate again within a broader framework of why at all we are actually discussing the whole thing, because we right now addressed 3 more specific questions, but why at all we should be bothered with these questions? Why should we bother whether international arbitration system is neutral or is not neutral, is accountable or is not accountable? Well, the first thing is, which you already mentioned in previous panel, they seem to have their own vested interest in the whole basically business related to international trade and investment treaties, right? So they have become somewhat of an autonomous actor with its own interests, which may introduce bias into the whole international regime, and that obviously can create problems for the parties concerned. And second of all, there is a serious debate whether international arbitrage system, international arbitrage panels should be the mechanism for resolving the disputes between investors and states, or states versus states, or investor versus states, right? Or whether there are some other alternatives, like national courts or other kind of arrangements which could replace international arbitrage panels. Right, so just to again, not to lose this broader question, this broader perspective of why at all we are discussing the whole issue. Tak bych vás, pane Rombald, teď poprosil, jestli byste mohli buď zareagovat na to, co bylo řečeno Jonathanem, nebo vlastně uvést vaši vlastní interpretaci a názor.
Děkuji za slovo, dobré odpoledne. Já bych chtěl nejprve uvést, jak může EGAP, kde jsem zaměstnán, exportně garanční pojišťovací společnost, využít dohody o podpoře a ochraně investic, zejména třeba řešení sporů mezi investorem a státem. Mnozí, jak tady jsou, tak ví, že pravidelnou součástí dohod o podpoře a ochraně investic je ustanovení o postoupení práv, takzvaná subrogation clause, a EGAP se zabývá pojišťováním exportních exportních úvěrů českých vývozců do zahraničí a ty úvěry mohou být použity na nákup investice. A v případě, kdy dojde k nějakému zádrheli ve splácení z té získané investice, toho úvěru na získání té investice zásahem orgánů státu, toho hostitelského státu, tak EGAP jako pojišťovací společnost může odškodnit toho investora a na základě toho ustanovení o postoupení práv vstoupí do jeho práv a může žalovat ten hostitelský stát podle dohody o ochraně investic. Bohužel zatím toto ustanovení se v praxi pojišťovací společnosti využívá málo, ale objevují se některé případy, kde toto zajištění by se dalo využít. Pokud jde o některé poznámky tady k projevu Jonathana, chtěl bych říci, že jasně jsou rozdíly v transparentnosti mezi ICSIDem a UNCITRALem. Ten UNCITRAL je méně transparentní, ale to vyplývá z toho důvodu, že pravidla UNCITRAL byla vytvořena pro arbitráže obchodní mezi soukromoprávními subjekty a tato pravidla se začala později používat i na spory mezi investorem a státem. Takže podstatou arbitráží obchodních je jejich neotevřenost, což znamená, že se rozhodují jenom mezi těmi stranami sporu bez jakékoliv jejich publikace, což platí třeba i o českém zákoně o arbitrážním řízení, který také preferuje zásadu neveřejnosti a z toho vyplývají pravidla UNCITRAL. Pokud bych chtěl navázat na to, co bylo tady řečeno ve vztahu k té odpovědnosti a neutralitě arbitrážních tribunálů, tak já si myslím, že základním nedostatkem těch arbitrážních řízení je jejich nepřezkoumatelnost, protože, jak zde bylo řečeno, tak pravidla ICSIDu umožňují ten annulment procedure, ale to se týká pouze procesních otázek a netýká se podstaty věcné ani podstaty právní. To znamená, že ty rozhodnutí nemůžou být přezkoumávána, pokud jde věcnou a právní podstatu, ale mohou být přezkoumávána pouze z hlediska toho, zda tribunál byl řádně nominován, zda se třeba člen tribunálu nedopustil žádného trestného činu a podobných otázek. Takže to je pouze omezené, ale tak mohou být přezkoumávána i rozhodnutí tribunálu vydaná podle pravidel UNCITRAL ad hoc tribunálem, a to podle New Yorkské úmluvy o uznání a výkonu arbitrážních rozhodnutí, kdy článek 5 také umožňuje přezkoumávání a tu annulment procedure opět ve vztahu k těm procesním otázkám neumožňuje přezkoumávat otázky věcné a právní. A k té neutralitě tribunálu, tak já bych chtěl zde uvést jenom takový případ neutrality, s kterým mám jistou osobní zkušenost. A tady byl zmiňován ten případ, kdy v minulosti, a literatura to popisuje dost jasně, byly dvě rozhodnutí ve stejné věci, a to byl Lauder versus Česká republika podle dohody o ochraně investic se Spojenými státy a pak bylo rozhodnutí ve věci CME Česká republika podle dohody s Holandskem, kdy totožná věc, naprosto totožná věc, byla dvěma tribunály rozhodnuta diametrálně odlišně. Jednou byla Česká republika zproštěna jakékoliv odpovědnosti a po druhé byla Česká republika odsouzena k plné odpovědnosti, jak tady bylo zmíněno, v řádu $100 milionů. Dle mého názoru to umožňuje právě ta velká diskrece těch arbitrážních tribunálů, kdy tady není žádný opravný prostředek proti jejich rozhodnutí, kdy úzká komunita, jak zde bylo opět řečeno, těch arbitrů jednou zasedá v tribunálu, jednou je na straně žalované, jednou je na straně žalující a tak to jde dokola. A ty arbitrážní tribunály rozhodují na základě precedentů. Takže existuje možnost, v podstatě, když tribunál si vytváří precedent třeba pro rozhodování v té jiné věci, kde už nejsem členem tribunálu, ale můžu být členem žalované, žalující strany a tak dále. Takže myslím si, že by měla zde být nějaký přezkumný orgán, který by zajišťoval konzistentnost rozhodování těch jednotlivých arbitrážních tribunálů, aby nedocházelo k takovým diametrálním odlišnostem v těch jednotlivých rozhodnutích. Pokud jde o otázku, jestli berou arbitrážní panely v potaz veřejný zájem daného státu, když vyhodnocují jednotlivé případy, souhlasím tady se závěrem, že některé ano, některé ne, protože například si můžeme vzít řadu arbitrážních případů, ve kterých je žalovanou stranou Argentina v návaznosti na devalvaci její měny na začátku, já nevím, 2001, 2002, nevím přesně, kdy to bylo, ale nějak tak. A na základě toho Argentina se stala žalovanou stranou ve více než 50 sporech, které byly převážně řešeny u ICSIDů. A kde ty některé tribunály rozhodly ve prospěch Argentiny na základě využití klauzule State of Necessity, kdy rozhodli ve prospěch Argentiny s tím, že řekli, že Argentina měla právo regulovat tu svoji měnu ve vztahu k těm podnikům, těch public utilities, jak bych to nazval, to jsou vodovody, kanalizace a takové, kde bylo to závislé na kurzu dolaru k argentinskému pesu a ty zahraniční investoři poté žalovali Argentínu. V některých případech tribunály rozhodly ve prospěch Argentiny, v řadě případů rozhodly proti ní. Nákladnost sporů. Tedy Jonathan zmiňoval nákladnost sporů ve vztahu k investorovi. Já bych to otočil a řekl bych nákladnost sporů ve vztahu ke státu. Protože na základě mých osobních zkušeností bych řekl, že řada investorů zahajuje spory jako způsob výdělků v té které zemi a zahajují takzvané, v anglicky to je frivolous nebo unmeritorious claims proti hostitelskému státu, kdy ten investor nemá tak moc co ztratit, kromě svých nákladů sporů a případně části nákladů arbitrážního tribunálu, protože většina tribunálů, podle mých osobních zkušeností, i když ten nárok investora je zamítnut, tak tomu státu náklady nepřisoudí a rozhodne, že každá strana sporu nese své vlastní náklady. A to i sporů, které byly nebo nebyly vůbec podložené. No a na straně státu to generovalo spoustu nákladů, a to náklady spojené s tribunálem, s chodem tribunálu, s odměnou rozhodců, s ústním jednáním tribunálu a tak dále. No a potom právní zastoupení státu a ty náklady nejsou malé a zatěžují samozřejmě rozpočty těch jednotlivých hostitelských států. Děkuji za pozornost.
Tak děkuji moc za reakci a myšlenky. Zeptal bych se nejdřív Jonathana, jestli bych chtěl zareagovat na pana Rombalda.
That's fine, yeah. Thanks for that intervention. I think I agree with everything that you've said. So it's true that the UNCITRAL rules were designed for private disputes, and that's one of the reasons why they have such a sort of why they favour secrecy and non-disclosure of proceedings. I agree also, as you say, that the exit annulment procedure and the procedures under the UNCITRAL system to prevent the enforcement of an arbitral award, both these systems are not appellate mechanisms. They don't give a court an ability to sort of review an arbitral decision and look to see whether the tribunal came to the correct decision. They're just ways to ensure that the tribunal stayed within the procedural limits of its power. And these this absence of appellate review is one reason, as you say correctly, why we have so many inconsistent decisions. And you pointed to the Czech and the Argentine decisions in particular. And I think the only other thing I would add there is that when you have such broadly drafted provisions, so the substantive provisions in investment treaties are generally very vaguely drafted, much more so than the equivalent would be in an international legal code. So you have provisions, for example, saying foreign investment shall be treated fairly and equitably. If you look at how much common law and statute you would need in the UK or Australia, which are the systems I'm most familiar with, to lay out the principles that explain how a government should treat private economic interests. It's incredibly detailed body of principle that deals with different rules in different situations, whereas in investment treaties you just have this one very simple, very vaguely drafted provision, and tribunals have to apply that and decide what it means. So it's not surprising they come up with very different views about what a phrase like fair and equitable means. And with the final point, which was about the problem of states being left with the cost of frivolous claims. In any legal system, private actors are going to game the system. I mean, it's normal when you go to a lawyer and you ask for legal advice and you say, well, what's in our best interest? That's going to encourage people to get what they can out of the system. And so I think the system needs to be designed with those sort of dynamics in mind. And I don't think there are enough mechanisms at the moment to screen out unmeritorious claims, and for sure much greater certainty about what the rules actually mean would be one way of being clear from the outset if an investor is just bringing a claim that really has no chance of succeeding at all and is purely a bargaining chip. So I'll leave it there, and I suppose we'll go to the floor unless you want to.
Yeah, we can go to the floor, but before that, if you don't mind, I would have one more specific and one more general question. Pan Rombald tady zmínil přezkumný orgán pro zajištění konzistentnosti panelu. Je existence takovéhoto orgánu v současnosti nějakým způsobem na nějakém fóru debatována, nebo je to čistě jenom fantazie zatím?
Já teď nevím, jak je to debatováno, ale kdysi to bylo debatováno na řadě fór, a to bylo jak z Fixidu, tak to bylo debatováno třeba v OECD a tak dále. Jsou snahy, ale zatím se neví jak, protože ty rozhodčí pravidla jsou různá a musela by se nějakým způsobem sjednotit a zavést jakoby jednotný přezkumný orgán podle různých těch rozhodčích pravidel.
Takže tam ty hlavní vlastně stakeholdři jsou členské státy nebo OECD, nebo vlastně jedná se o nedostatek politické vůle, nebo co je vlastně tou hlavní překážkou k tomu, aby se skutečně, řekněme, do toho šláplo a došlo k ustanovení takovéhoto přezkumného orgánu.
Teď nevím, přesně nemám jako aktuální informace, ale myslím si, že ani tak nedostatek politické vůle, jako spíš není zatím vyjasněno, jakým způsobem to právně provést.
A druhou otázku teda, kterou bych položil panelistům, nebo vlastně možná i tak trošku do vám účastníkům diskuze, je vzhledem na to, co všechno teď bylo řečeno o těch arbitrážních panelech, očividně je to hodně kontroverzní mechanismus, hodně kontroverzní instituce. Jestli to, čeho chceme dosáhnout, je reforma vlastně tohto systému, nebo jestli chceme vlastně se bavit o nějakém skutečně novém alternativním způsobu řešení vlastně sporu mezi státy a investory. Jestli se nám jedná ještě o tu reformu, anebo jestli chceme totálně nový systém, nový mechanismus a jestli je to průchodné, jestli je to realistické, to jsou samozřejmě všechno otázky, které jsou s tím spojeny. Takže to je jenom takový nápad, jak můžeme dále strukturovat tu debatu, možná se můžou k tomu vyjádřit teď panelisté, ale samozřejmě pak je prostor pro jakékoliv jiné otázky z vaší strany. So I don't know if...
Well, maybe very quickly. So that's the $1 million question. Do we want to try to reform the system or just get rid of it altogether? It really depends on whether you think there are significant benefits that flow from investment treaties, and particularly thinking about the substance of investment treaties. Because if you think the system as a whole creates considerable benefits, then this imperfect situation, these imperfect procedures for dispute resolution might be worth sticking with. Maybe we should change them a bit, but it might be worth sticking with it. Whereas on the other hand, if you think that the system as a whole is not delivering significant benefits, then it raises serious questions about why we are also institutionalizing it through these procedures of adjudication and dispute settlement that don't operate as well as we would like. So my own view, for the most part, is that the investment treaties don't create a lot of economic benefits, which means that, for the most part, we'd be better off without investor-state dispute settlement. There are particular areas where I can see that there is some value in investor-to-state dispute settlement, and that's mainly in the sort of situations where realistically domestic courts aren't functioning or can't be expected to function. But we need to be if that's the case, then we need to be much more cautious about where this is used. And certainly this current system we have where investor-state dispute settlement and investment treaties are seen as a generalized system of investment protection, I don't think I would support that. Yeah.
Excellent. Thanks a lot for the answer, for the sincere answer. Pane Rombald, chcete reagovat na toto kolečko?
Já si myslím, že ty dohody za určitých případů mají svoji hodnotu, ale že základním problémem je asi najít tu správnou rovnováhu mezi právem regulovat a těmi principy ochrany investorů, které jsou v dohodě zakotveny. Protože o tom ty dohody jsou. Dohody jsou o tom, že na bázi mezinárodního práva veřejného omezíme právo hostitelského státu regulovat na svém území bez souhlasu a nemůže změnit tu regulaci bez souhlasu té druhé smluvní strany. A teď jde o to najít tu správnou rovnováhu mezi těmi neoprávněnými zásahy do fungování investice na území hostitelského státu a tím právem regulovat na straně toho hostitelského státu.
Děkuji za odpověď a teď bych teda nechal prostor posluchačům v obecenstvu, takže buď můžete reagovat na předešlé otázky, anebo se zeptat něco úplně nového. Paní Simonová.
Děkuji obou řečníkům zase za velmi zajímavou prezentaci. Já bych se chtěla zeptat jednu otázku, která je možná triviální, ale myslím, že je velmi důležitá. My máme tady dohodu mezi dvěma státy o ochraně investic a když dojde ke sporu, tak ten spor se neřeší mezi těma dvěma státy, které uzavřely tu dohodu, ale najednou mezi někým, kdo z té dohodě si myslí, že byl poškozen. To mně připadá, teda nejsem právník, ale připadá mi to nelogické. Ty spory by se měly řešit mezi těmi státy. Čili ten investor, řekněme, já nevím, z Holandska, by se měl obrátit na svou vládu a pak by měl být nějaký rozhodčí soud mezi vládou Nizozemská a České republiky, který by rozhodl v tom konkrétním soudním sporu. Takže se ptám teda, vzhledem k tomu, že jsou to dohody mezivládní, jak vůbec došlo k tomu, že teda arbitrážní řízení je najednou na úrovni teda podnikatelské, víceméně, kde má každý svůj zájem. Takže to je jedna věc. A druhá věc, jestli někdy bylo diskutováno, nebo třeba především v Evropské unii, že ta arbitráž by se vlastně měla konat na úrovni vlád, že teda by mělo být rozhodčí řízení. Pokud je účastníkem vláda jedné strany, tak vlastně ten rozhodčí soud by měl být na úrovni vládní, čili ta arbitráž by měla být na úrovni mezivládní. Jestli mi můžete k tomuhle něco říct. Děkuji.
Tak děkuji moc za tuhle v uvozovkách triviální otázku. Je to otázka, kterou jsem měl i já v hlavě včera na večeři s Jonathanem a Markem, akorát jsem se k ní nedostal, takže jsem rád, že jste ji vznesla. Takže chcete pan Rombald nebo Jonathan first?
It is a good question, not trivial at all. In fact, the way that international investment disputes used to be resolved was more or less as you describe. So it was resolved between the state of the investor and the host country government. Generally not through not through arbitration. Generally just through negotiations, and then occasionally, in very limited circumstances, through arbitration agreements as well. So famously, there was an agreement between the United States and Mexico, I think in the 1920s, to arbitrate claims arising between private individuals. But the claims were brought by the states, so it was the United States on one side and Mexico on the other side. Is this a good system? Well, the reason why investment treaties were signed in the first place was partly to avoid this system, because the politicization of disputes through their espousal by government meant that often an investor's case wasn't pressed by the government of the home government because they thought it wasn't worth causing friction over the issue, and then when the claim was pressed, it would often become tied up in a lot of other issues that were always on the agenda between the two governments in question, and so there was a very haphazard system of investor protection. So personally, the state-to-state model, I'm not in favor of it, and particularly because there is this unhelpful mercantilist idea, I think, that the interests of the private party are the same as the interests of the home country, and they're not the same interests, even if they're aligned to some extent some of the time. But as a matter of principle, it's not the same thing. So I think any system that embodies the assumption that the private actor, which is the investor, is somehow the same thing as the home country, to me is problematic. That said, a lot of people arguing for reform have argued for a return to state arbitration, so to not negotiations between governments, but a formal arbitration procedure. And actually, many investment treaties do contain parallel provisions allowing for state-to-state arbitration. It's just that home governments very rarely use those claims. There's only ever been 3 that are publicly known in the 40-something year history of investment treaty, while there have been hundreds of investor to state claims. So at least while there are alternatives, there doesn't seem to be much of an appetite among governments for a legalized model of arbitration between governments.
Jestli můžu, abych na to zareagoval, tady to už bylo naznačeno v tom dopoledním panelu. Ty dohody o podpoře a ochraně investic vznikaly v 60. až 90. letech minulého století. První, jak bylo řečeno, byla dohoda mezi Německem a Pakistánem v roce 59 a ty dohody byly v podstatě podmínkou toho, aby ten zahraniční investor do té země, které šel, takže vznikaly dohody na úrovni, ale současně si ty domácí státy vzdávaly své suverenity. Vzdali se suverenity a vznikl takový hybrid, kdy jsou uzavírány sice dohody mezi státy, ale ten hostitelský stát se vzdává své suverenity a podřizuje se tomu arbitrážnímu tribunálu. A je to všechno za účelem toho, aby přilákali té zahraniční investory, protože ten způsob řešení sporu stát to stát je prostě neefektivní. Jednalo by se o takzvanou diplomatickou ochranu, kdežto tady se dává přímo tomu investorovi právo, aby žaloval ten hostitelský stát a to arbitrážní rozhodnutí, aby bylo přímo vymahatelné ve všech státech, které jsou členy New Yorkské úmluvy o uznání a výkonu arbitrážních rozhodnutí. Tato úmluva je z roku 58, jako Česká republika je členem a valná většina světového společenství států je členem. Takže kdekoliv má třeba ten odsouzený stát majetek, tak potom ten investor by mohl vymáhat na území kteréhokoliv členského státu to rozhodnutí v souladu s místními předpisy toho kterého státu, kde má ten investor majetek, tak nejen v tom hostitelském státu, ale kdekoliv na světě, v tom členském státu té New Yorkské úmluvy. Takže to vzniklo tímto způsobem.
Děkuji za vysvětlení. Další otázky? Mark, please.
Well, the question of alternatives, and do something different. For instance, the World Bank, I think, and many other instances are monitoring the ease of doing business in all countries of the world. There are also classifications of the rule of law in countries and so on. Belgium very recently ratified an agreement with Panama, a bilateral investment treaty, with the clause that violates the European Constitution, the European treaty, still in it, knowing that this was not allowed. And when we had a discussion about this in the Parliament, we started looking also at these indexes, and Panama ranks very high on the index for legal security within the country. No investors have any problem with getting their claim heard by a local court, and there's appeal and whatever. So, what was the added value of having this agreement with Panama? Zero. The problem is that there were companies that wanted to invest in Panama, especially the Belgian dredgers, who are world famous. So they wanted to, dredge the Panama Canal and expand the port and whatever. And they felt that they needed it, and so the government did it to please one of their main exporters. In the whole discussions on the new EU investment policy, we have had discussions with many people, and what we learn is that many people who are in the decision-making process actually do not know what bids are about. They don't know what the consequences are. We talked to people who negotiated bids in the past, and they said, look, this was the kind of agreements that we had in our pockets when the prince went to visit these countries, and then to celebrate the partnership between the countries, we signed the bilateral investment treaty. They didn't look at it, we didn't look at it, you know, we signed it. And even just very recently, Belgium signed a bilateral investment treaty, I think, with Kazakhstan. It was sent from Brussels to Kazakhstan. It was signed and sent back, not even negotiated. So it's amazing how these things can go on and go on. And there was UNCTAD, who used to organize like bid signing parties with developing countries, and the developing countries thought, you know, if we sign these things, then we're going to get investments. None of this is true. So how come this can go on and on and on, and that we cannot stop it? And it has to do a lot with inertia. Again, the Belgian example, confronted with the fact that nobody in the ministerial cabinet and very few people in the administration and the foreign affairs department and the economic department actually knew what bids are about. When we confronted them with our concerns and with good papers from, you know, experts in the matter, the only thing that they did was to call the Belgian Business Association and say, what do you think? No, should keep him. And that was the end of the discussion. So how can we change such a system if there's so much inertia, so much business as usual, so much acting without thinking, so much confirming with the small community that you are? You know, it is difficult for somebody in the Trade Policy Committee to say, look, you know, I actually think that we should not have bids. Then this guy is almost thrown out the window as a heretic. Confirm and confirm and confirm and maintain, and making changes are very, very difficult. That's what I find, very sadly.
Thank you, Marc. I think you basically also referring to the situation in Czech Republic in terms of how much the agenda is known within circles which should be relevant, and we should take this agenda seriously. And probably it's the task of think tanks and an NGO community to pick up the issue and raise awareness on it among civil service, but also business circles, I presume, and governmental institutions such as governmental institutions or parliament. So that would be the role for the NGO analytical sector, if you want. Do you want to react, somebody, to Marc's?
I'm not sure it was a question, except to say that I agree.
Yeah,
I mean, there is no.
But you, Marc, for instance, you have worked, I understood, for many, many years on the topic as such, but also on raising awareness on the topic amongst the relevant stakeholders and circles. So how come that now, 2012, and you still seem to be very skeptical and is it that you haven't done a good job, haven't tried enough?
Well, the point is that, like I said, I should maybe start writing a PhD on how decision making works, and I understand that you know, we have written letters to members of the parliament stating our arguments, and we got letters back like, you know, but our party says this is good, and so I'm voting in favor. And then I said, you know, please think for yourself, examine this policy, discuss this, and so. And it is not happening. But we had, over the years, we had several successes, but these are small bits and pieces. To tell you a secret, for instance, the fact that there is in the mandate for the European negotiations for investment policy, there is this paragraph on the right of the governments that this should be without prejudice to the right of governments to take measures. It was Belgium who fought very hard for that. And Belgium fought very hard for that because we had mobilized in the country for that. And so that was a warning. So the fact that this was now in the mandate is because in one country there was a political debate and there was some result and the government lived up to it and they managed to get it through. And that's small. And now, but you know, then you think, okay, fine, we have that in the mandate. So now say.
Sorry, it is in the mandate of
the mandate that the European Commission received from the Council to negotiate investment protection agreements with Canada, India, and Singapore. And also, there's 4 other countries who are in the pipeline. So Morocco, Tunisia, Egypt, and Jordan will be the next countries with whom the European Commission will negotiate investment protection. So we managed to get that in the mandate. So that's nice, good result. But now debates are reopened because now the member states are saying when it comes to the text of the agreement, It says, yes, it should be without prejudice to the right to regulate, but the right to regulate is actually not affected. So with what we have in our bilateral investment treaties, this doesn't undermine the right to regulate, so we can continue as we were. And so that, in that sense, some member states reopened the discussions, and yes, it is in the mandate, but I don't see it anywhere appearing in the negotiating text. So this has to be followed up and so on. And then the difficulty is that the decision-making process is so untransparent and so closed that by the time that you know what is happening, things have already been accomplished. So our prime objective and demand in any discussion with our trade policy officials is, please, transparency, openness, consultation. Let's take trade and investment policy out of the ancien regime from before the French Revolution and bring it into the modern democracy of the 21st century. But unfortunately, that is still a long uphill struggle.
And why is it that there is such a lack of transparency? What's the
I think because the interests that profit from it, they want to keep it like it is. And the more there is discussion and transparency about these things, the less that the protection is maximum, and the more there is protection of policy space and the environment and such. And there is some consensus that, let's keep this inside. On the other hand, it's also always very complicated and very technical, and it's very difficult to get a member of parliament to invest in that. Yeah. Because he says, look, if I would invest in this, it would take me a lot of time before I understand it, and then I have to convince others and so on. And in the meantime, I cannot be with my constituency, my voters. They want to see me on something more tangible. And so of the cost benefits of being a parliamentarian, it doesn't award them to get involved in these very complex things that are so difficult to change. It's a big titanic boat, and that's why the Lisbon Treaty and the fact that the European Union now had to design its own new investment policy was such an important opportunity, because at least there were going to be debate, and there was debate, especially in the European Parliament.
So we need to maybe work more with the constituencies so that they convince their representatives.
Yeah. And so
try
to find ways to bring this to the constituencies, the voters of the members of parliament, so in a simple way, so that they understand what is going on. And for instance, why does the Czech Republic has to pay $270 million for this and that and such, while and what can we do about it?
But it's a vast amount of money, and also taxpayers' money, so it's quite surprising nobody picks it up in the national parliament.
There's a Chinese investor that now has filed a case against Belgium, and I think it runs into like 2.7 billion euros. This has to do with the Fortis Bank. So we immediately made a press release out of it, but none of the press took it. They said, what is it about? And that was not sexy enough, so it didn't even get into the newspapers.
Picture?
I have a question to Jonathan. What would be your alternative? Would you say we will exhaust national law, or
in general? Yeah, it's difficult to come up with one alternative for all countries everywhere. And I think this is a discussion I'm still involved with, and we're still trying to understand better the consequences of these agreements. And I don't have a final view, but if I had to say one thing of a starting point for a discussion, it would be treaties where you would need to litigate in domestic courts first, because that encourages investors to see their interests in improving the reliability of the domestic court system, rather than in thinking that the best thing for them is just to try and opt out of the domestic system. So you would have a requirement to litigate in domestic courts first. You would have lower standards of protection, so you would be clearer that maybe the treaty prohibits outright expropriation, but you wouldn't have these sorts of ideas about treaties protecting certain sorts of expectations of investors, some of which have, by some tribunals, not by all tribunals, but some tribunals have taken some quite expansive views of this. So you would definitely redraft the substantive standards, and then if you're going to retain investment treaty arbitration as the kind of recourse after you've litigated in domestic courts and you're not happy with the outcome there, or after 3 years of litigation in domestic courts or whatever, then I think procedural changes for the system of investment treaty arbitration, and there's political obstacles to having an appellate system, and I'm not sure. There's difficulties with that too, because if an international investment court gives a ruling, whatever they say is going to have a lot more binding authority. So that's great if you trust them to make rulings that you agree with, but if they make rulings that you think are so I'm a bit unsure at the moment about these ideas of appellate mechanisms, but certainly, a strengthened roster for review in annulment proceedings. I would ideally get rid of the party appointment. So Jan Poulsen has proposed getting rid of party appointment altogether and just having a roster of arbitrators. I think that's a much better idea. It means you have to pay a lot of attention to who appoints people to the roster of arbitrators and how that's managed, so it can come with its own problems, but I think in principle that's better than party appointment. So those are, I suppose, those three things: local courts, narrower standards of protection, and procedural reforms to investor-state arbitration are three things that I would do now to change the system.
Já bych měl pár poznámek tady k tomu, co právě řekl Jonathan. Jak řekl, že preferovat jako v první instanci domácí soudy, tak já si myslím, že v některých zemích by to šlo, v některých zemích asi jsou jasné některé země, kde ty domácí soudy víme předem, jak by rozhodly. Takže jako myslím si, že v těch vyspělých zemích jako je to dáno už tím, že třeba mezi těmi vyspělými zeměmi dohody o ochraně investic neexistují. Mezi tou třeba starou 15 EU, mezi těmito zeměmi a Spojenými státy neexistují tyto dohody, například existuje jenom dohoda o přátelství, obchodu a plavbě nebo námořnictví a ta nemá žádné řešení sporů, takže tyto země mezi sebou žádné arbitrážní dohody o podpoře ochraně investic, včetně řešení arbitráže, nepotřebují a fungují tyto země. Takže ano, mezi jistými zeměmi by to šlo, ale jako úplně ty dohody zase bych nezatracoval, někde mají své opodstatnění, protože ne ve všech zemích funguje právní řád zcela nezávislé, a takže v těch zemích mají tyto dohody, včetně arbitrážního řízení, své opodstatnění. Potom bych souhlasil s tím, že asi by se měly lépe vymezit ta ustanovení těch dohod, ale třeba nesouhlasím s tím, co řekl Jonathan třeba o vyvlastnění. Myslím si, že dneska není problém jako ve vztahu k četnosti těch sporů vyvlastnění, ale problém je tzv. Fair and equitable treatment. To je ustanovení, jehož obsah v podstatě není v té dohodě dán. Je to velmi široké ustanovení, je to absolutní ustanovení a jeho obsah dávají teprve rozhodnutí těch jednotlivých arbitrážních tribunálů, co v které dohodě toto ustanovení znamená, a na základě toho jsou ty arbitrážní spory poté rozhodovány. A v některých případech, dle mého osobního názoru, zase dochází až k tomu, že třeba ten arbitrážní tribunál vykládá tu určitou dohodu i proti vůli těch smluvních stran, které tuto dohodu sjednávaly. Takže zase se vracíme v podstatě tam, kde já jsem teda byl na začátku, a to je nějaké přezkumné řízení, které by dohlédlo na to rozhodnutí a navrátilo ho do určitých mezí, kde by se ty arbitrážní tribunály měly pohybovat. Potom tady byla řečena zajímavá myšlenka jako jmenování do seznamu. Souhlasím s tím, že by to bylo možná dobré, ale závisí na tom, jak řekl Jonathan, kdo by jmenoval a poté, jakým způsobem by ty arbitři byli z těch seznamů vybíráni nebo určováni. Kdo by zase určoval ty arbitry z těch seznamů, kdo bude v těch jednotlivých arbitrážních tribunálech zasedat a rozhodovat ten který konkrétní spor. Děkuji.
Děkuji moc za vstup. Jsou nějaké další otázky z publika? Tak v tom případě bych již tak požádal o závěrečný koment ze strany z našich speakerů. Jestli by chtěli ještě nějak zesumarizovat tuto debatu a jsou spokojeni s výsledky naší diskuze. Co, Jonathan?
Yeah.
Sorry.
I'm satisfied. Just to clarify what I was saying before, because I think I didn't explain myself quite clearly. So I agree with you, Mr. Rombald, about the expropriation provisions are not the problem, and that's an element that would be retained in, I think, ought to be retained, and it's some of the ideas that tribunals have come up with when interpreting fair and equitable treatment provisions that are I think the most serious problems with the current substantive rules. Yeah.
Tak já bych teda to i druhý panel tímto uzavřel a poděkoval panelistům za skvělé vstupy a taky za reakce z publika. Chtěl bych poděkovat, že jste se zúčastnili, vám jako publiku, chtěl bych poděkovat panelistům a hlavně našim dvou speakerům, Markovi, so thanks a lot to Mark and Jonathan, who have arrived just for this occasion to Prague to give their presentations and share their views on the topic. I would like to thank Bonnitche from TNI, which is a partner organization of Glopolis, and who, with her colleague Cecilia, has helped a lot to make this event happen and basically to get Mark and Jonathan to join us here in Prague. So without her support and without the support of Transnational Institute, this would not happen certainly. I got scared by the sheer idea of organizing this discussion because I was, oh my God, who's going to talk and who is going to come, but it seems to have worked out. And I would like to thank Chris Maritz, especially because she has completely overtaken the organization of the event after I left Glopolis in mid-October. So I could just safely arrive to Prague and moderate the event, but all bulk of work was basically done mostly by her. So thanks a lot, Chris, for this, and I owe you, more than a beer, I guess. So if I come back to Prague in January, I will think about how to reward you. Okay, so thanks a lot for everybody, and I think there are some nice baguettes, and we have, well, as long as you can stay, probably until. Is there some time limit when we need to leave? 5 o'clock. Oh my God! Okay, I need to leave in 40 minutes, so please. So thanks a lot, and please. Take a bite.